take our noon recess. We will resume this afternoon at 1:30. So I would ask that each of you be back here shortly for 1:30 this afternoon. Again, I want to caution you not to gather any information about this case from any source outside of this courtroom, and that means, of course, the media that is leaked, like newspapers, TV, but also any media in terms of anything on the internet, things like that. So with that, we will see you at 1:30 this afternoon. Did you mark that other disc, number 3?
Exhibit 3, yeah.
Okay, and then
you want me to mark these as 4 and 5?
Yeah, if you would, just so that we can keep them properly identified. And can I have them, please?
That's the only ones I had prior to the complaint were his basis for the statements within that. And he even went in specifically and said the formatting and stuff that had been done. And so I wanted to show that we followed the rules as best we could with the Supreme Court of Appeals, and that it wasn't there are no threats contained within it. It is a normal filing that would go into a court asking for relief and remedy. There's nothing extreme about it, and he testified and said that's what he based the complaint upon for previous filings to the date of the 23rd of September.
Of course, then you're getting into extraneous matters to impeach or attempt to impeach a witness. But I'm going to allow the complaint to be filed, or to be admitted, because I think that's what he said was the complaint, or at least that's my recollection. I don't know that it's necessary to introduce the entire file.
So that would be the May 22nd filing that's 20-some pages with a judicial notice and maybe some affidavits of service, possibly, I'm not sure. The initial filing was 20-some pages with a 6-page judicial notice.
Yeah, it's several pages. I didn't count the number. I mean, you'll be able to look at it to make sure you know what it is.
But that's what you're referring to, the very first filing, not the additional ones at later times.
Right.
Correct. Okay, yeah.
Because there has been some discussion about filings and what, if anything, those meant or the effect of them. All right. Are we otherwise ready for the jury?
Yes, sir. Just a question on that. Since I think I had only went through 2 with Phil on the stand, do I need to bring him back in to admit the 2nd and the 5th one? Number 2 and number 5?
Not number 2, because I think you laid a foundation for that.
Okay, I just want to make sure. So I just need it for number 5 then?
Do you need a foundation for number 5, the Supreme Court file?
I believe so.
Okay. Then he will will need to do that.
Just 5, and that is 5, right? The complaint was
Right.
5, and 2 was the 15-minute clip.
Right.
Okay.
Let me make sure
The only other issue I have would be, and I'm not sure if my computer will interface with the projector.
I think,
Yeah. Okay. And I think it's 2035 roughly is where it starts, and about 38 roughly.
That probably the first thing he wants to do. Well, it doesn't matter, just like.
I mean, do I need to go ahead and show this and then bring him in for the papers, or do we wanna go ahead and, that's all he's being called for, was this stuff.
it's up to you in terms of whether you wanna just go ahead and admit the, call him back in and have him go through, defendant's exhibit 5, or whether you wanna play defendant's exhibit 2, it's up to you.
I was just asking the preference we have, it doesn't matter to me, he's fine with sitting out there, so I'd say we just go ahead and play this, and then I'll call him back in for that.
Defendant's exhibit 2, okay. If you wanna go ahead and get that keyed up or lined up.
And Judge, would this be a convenient time to go over with the defendant the usual colloquy with respect to defendant's testimony?
Well, I mean, I already have, but I guess we could go ahead and do it again. I know that I asked you about exhibits, before we took the break, just so I could review them over the lunch hour and try to save some time with having the jury here, while I listen to exhibits and we did that. Of course, I know that Mr. Hudock is on the stand. Are you gonna have any other evidence besides your evidence to Mr. Hudock?
No one else is here.
Are you gonna testify?
I believe I'm gonna have to, I believe so.
Right. You understand that you don't have to testify?
Yes, and I mean, me saying that I'm probably going to is not that I have to.
You don't have
I can
to.
make that choice when the time comes, correct?
You can make that choice as soon as all your other witnesses testify.
Okay.
If Mr. Hudock's gonna be the only one, then that's fine. So yeah, anything you say now is not binding. I mean, if you say no, you're not going to, but then you decide to, that's
Okay.
fine. If you say you're going to, but then you decide not to, that's fine. But you understand that you don't have to testify.
Yes.
Okay. And that if you do testify, that the prosecuting attorney will be entitled to ask you questions. You understand that?
Yes, I'm just not sure of the scope of what he could ask, that's what I'm unclear of. Can he ask specifically to what I've talked about, or is he open for anything once I go up there?
Well, he can cross-examine you on any issue that you raise.
Okay.
He can also cross-examine you on any issues that relate to credibility.
Okay.
And a prior felony criminal conviction could be considered impeachment evidence.
Okay.
I'm not saying it is in this case, but it could be. And I mean, I guess there's some limit on what he can ask, but you are a party, and so the rules of evidence indicate that if a party takes a witness stand, that the cross-examination is not limited to issues that are testified to on direct examination. So there is a wider scope of cross-examination for a party than for a non-party witness. Generally, a non-party witness, the scope of cross-examination is limited to matters that are brought out on direct examination. For a party, which you are, then it is broader. Now, that doesn't mean that there's no limit, but it's not limited solely to what you testify to.
Okay, and during the time that if I testify, can I have him sitting here as counsel to object to anything that he feels, since I will be busy formulating, answers or testifying to any objections or anything that may come up from the other side?
If you want him to do that, then he can. I mean, that's one of the things that he was appointed to do, would be to assist you, and if that's to assist and make sure that the cross-examination does not get too out of range or out of scope, then that's fine. Also, if you don't testify, the jury can be instructed that you don't have to testify, and that they cannot consider the fact that you didn't testify as any evidence that you did anything wrong. Further, we've talked about this before too, you have the right to call other witnesses and present other evidence, like you marked 5 exhibits so far, and you've called 1 witness. You understand that you have the right to do that?
I understand I have the right, yes, but it's just not there.
Well,
No, here, and I didn't have time to go through the paperwork to see what I could verify and what I couldn't.
all right. Are we ready then for the jury?
Yes, sir.
Okay. Keep it up?
Yes.
Okay. Is that right? It says 2035, Mr. Deegan?
What I wrote down, if my media player was accurate, it's not the same one, it's not Windows, so I'm not sure how accurate it is.
I didn't hear your voice until about 23, but what I heard between here and 23 was neutral. It was somebody else.
Well,
maybe 2 other
if we want to check real quick before bringing him in, all I wanted was just what I had said. But we don't have to have anybody else speaking.
Nah, that's fine.
Okay.
Like I said, it's neutral.
Okay.
Good afternoon.
Good afternoon.
Just so that you all are aware, this is, I think it was discussed in testimony prior to us taking a break. This is a disc that has been marked, and that's Exhibit 2. And this is, as the other exhibits from the state, it's the disc and the information on it that is the evidence, not any transcript, although I don't know if there is a transcript of this. But it's the disc, and that is the evidence, not any transcript. So.
we've come to a major signpost on the globalist path toward absolute demonic tyranny with the Pope's plan of operation. And I think Alex gave one list, one of the best overviews and synopsis of exactly what the Pope is up to. And I think we have to really look at where we are in time and space and in this globalist movement. So maybe later on I'd like to play a few minutes of it because sheriffs, they don't exist, because they violate their oath as soon as they take office. And all of these things are to keep you complacent and doing nothing. With that being said, I'm not sure how many more calls I'll be on. It depends on what Jim and Steve wish to do. I can educate you on true law, contracts, and maxims, but it's quite apparent that most people don't wish to utilize the knowledge, so I'm not sure what effect it would have. We still have set forth things that everybody can do, such as petitioning, complaints, going directly to your local officials, and forcing them to do other things. I had a call with someone earlier that had a pretty good idea, but I'm not sure that it would necessarily work in enough time to stop what's going to happen. We have state money interest in Karen Gudetz, the IMF, BIS, the Vatican, that want you to just think everything's going to be okay when they leave the UN. It's not. No one's helping you. No one's doing anything on your behalf. It's still a game of see how much they can steal from us, and until the majority of Americans stand up and say they've had enough, and then that's it. They even do it in time. Nothing will change, and your children's future is bleak. With that, I hope the agents and operatives that have been chasing me, you can keep on chasing me, boys. I haven't went anywhere. You know where I'm at. None of you have shown up face to face to do anything. You can't stop what I'm doing. I will continue writing whatever I feel like writing, and I will continue putting it out as long as I feel like putting it out. And there's nothing, anything any of them can do to stop that, because they're all cowards. Hide behind a microphone, a telephone, a video camera, and talk useless garbage that makes no sense to anyone that has half a brain cell. So I would implore the people to go ahead and continue petitioning, filing complaints. We should have already had a complaint filed in every state. There should have been a complaint filed in every district court in America. No one could even do that. So as far as I can see, it's probably best for everyone to go ahead and kiss your children and grandchildren goodbye, because very shortly you will probably be leaving this earth, and hopefully they will with you so that they avoid what's coming. I've given you the best intelligence and information on the inside workings, and no one seems to care. And so what the Pope's coming to do will be done, and there's really nothing you can do about it, one person at a time. Once again, I will state that the three of us have nothing to do with any idiots that show up on Thursday, because the majority of them will be federal operatives seeking to cause a problem. So we have absolutely nothing to do with it. We don't wish to see violence, and had the American people shown up in force, there wouldn't have been violence. The cowards and traitors would have left office and would have probably left the state. And within a month, you all could have had free states. And within a few months, you could have had a free country. But we've seen where the American people are at. They don't want it. They like what they have. And so I'll accept that. I will continue to free myself. I'm working on something for the children of Earth, since no one's protecting them. I will do something to do that. We have a few other angles. If you see it work, you see it work. If you don't, you don't. With that, I really don't have anything more to say. Unless Jim wants to say something, or Gene or Phil, I guess we can open it up for questions or comments. Well, it's a good thing this isn't radio, because they pull us off the air. You want to stop?
You can push start six.
I can hear you now, Gene.
Well, I'd just like to say, what we've done is still out there, so, can't twist arms.
No, that case is open, it's not going anywhere, we're not pulling it or anything like that. That there's nothing to be done with it, because we don't have the assistance, correct, Dean?
Yeah, and they will say, just like the dodos that was on the radio there, well, it wasn't thrown out, it's still there, they're in violation, they have been in violation, so, they just don't choose to do anything. It's still there, and what happened, happened, and they're beat, but we have no enforcement to enforce it, so, other states have did the same thing.
Absolutely, I would recommend it, to go ahead and get it on the public record, and get them in default dishonor. There's been some suggestions of, just, public announcements that they've vacated their offices, or their employment for their criminal actions and attempt to, put people in their place, but I think that, unless you had someone that would, assist you with that, with, the threat of force, you would find yourself probably arrested, by their operatives called police and sheriff, FBI, as, impersonators themselves, when in fact they are the impersonators. You can attempt to do what Judge Anna did, only I would recommend you doing it on a much more open scale, because she can't prove she was elected. She can't prove that she's a judge, and the judges and, the court system is 90% of the problem in this country. And so, why we would want to, reenact what got us here is, beyond me. I think that, firmly fits within the definition of insanity. But anything that I attempt to do on any massive scale will immediately have foreign operatives around it. So there are maybe others that could possibly do something, that are not watched very closely. And, you may be able to get something done in your state, but I don't think people realize that, once you leave the UN, the book is written, and, they will continue to carry it out. Only now, if you get in their way, they will just murder you on the side of the streets, as they're doing to our children daily. And, the militia will continue to sit by and just watch it happen. It goes to show where our country is really at, and, what's coming, the judgment, we really do deserve it as a nation. I hope it doesn't happen, but it looks like we're going to go through a pretty severe judgment for our inactions in times past and times present. The case is still there. If we can get an actual group that's not 50% federal agents, we'd be happy to work with them on something to, remove these persons and start the change. But the likelihood of that at this point, is non-existent. As you can see, the man that brought us everyone, is not here tonight, is absent. And so I think that would be pretty indicative of, what he actually was. With that, I really don't have anything else to say. I'll continue doing what I'm doing, and when it's done, you people will see it. But it's still up to the people of Earth to enforce anything. They're not going to give up their power. They're criminals. And, if you think you can go in there and get criminals to actually give you a ruling that they're criminals, then you're as insane as the dodos from last week that were on here. And, you're either insane or you're on drugs, and if the drugs are that good, I would like some, so send them to me, please.
If anybody has any questions, you can press star 6 and follow the directions. Comments?
Okay, well, I'll leave it with, there's a set of books by Lysander Spooner. best we could in West Virginia with 3 little people. And there's really nothing else that we can do at this point other than say the case is there. They've defaulted and dishonored themselves. We're the last one standing, and we have the authority to do whatever is needed for the children, and we will take whatever actions we think is proper and necessary, regardless of what the federal agents say. Lysander Schooner.
When did you see those Q&As? My board's down.
Okay. Let me unmute the first one.
Mr. Deegan, I think that's the end of the recording.
Okay.
You want Mr.
Udar back in.
This is the.
What?
He thought he was done and he left. Can you? That's according to Mr. Deegan outside. understanding is that you were wanting Mr. Hudock simply to identify the Supreme Court filing.
Right. And I mean, that one is, I'm a signatory, I mean, I can verify that.
Well, I'm gonna go ahead and admit it.
Okay.
And unless you have some, other than relevancy, unless you have other objections.
None other than that.
Okay. But I'm gonna go ahead, 5A is the petition or complaint that was filed that I indicated I was going to admit. I'm gonna go ahead and admit that. And then the remainder of the filings will be Defendant's Exhibit 5, and those will not be. So, does that do away with the necessity then to call Mr. Hudock back?
Yeah, that's all I have for him unless he has something.
Well, that's what I was gonna ask. Do you have any items of cross-examination that you were wanting to do with Mr. Hudock?
I mean, if he's not around,
I mean, I have a phone number, if someone can call him, I'm sure that he's probably still in the area. I don't know why he left, I told him that he would have to testify to the 5 objects, and so I'm not sure why.
just based off of just these two things, I'm fine with it.
Okay. All right. Do you have any other evidence?
No.
You're not gonna testify?
Well, I was speaking with him about that.
Okay. All right.
That issue.
Judge, could he and I have 5 minutes?
Okay. Do it here, you can do it back in the holding cell, doesn't matter.
You got holding cell.
How much five A long?
5 and 5A.
And that's just my definition right in here. Well, I would at least like to see that customary definition inserted.
Of course, the standard at this stage is not proof beyond a reasonable doubt. But the court would find that it is reasonable that a jury could find that the evidence does establish the offense of making a terroristic threat, in that there was statements made by the defendant about injury or death to others, and the conduct that was planned would affect the conduct of a branch or level of government, and could be considered to also retaliate against the branch or level of government. Retaliation because they, in Mr. Deegan's eyes, were not doing what they were supposed to do, and of course affect the conduct of a branch or level of government because it was his intent, or at least his expressed words, were to replace members of the government. So there was both a political aspect of it as well as at least a threat of violence. So the motion is denied. All right. How much time do you want to argue?
I believe I would, 20 minutes, 15, and then 5 for rebuttal. And I talked to Mr. Deegan and we agreed on that.
20 minutes, Mr.
Yes.
Deegan?
Yeah.
Do you want notified at the end of any amount of time, Mr. Deegan, just so that you know that you're gonna need to wrap it up?
No, I doubt, I haven't had time to prepare. I doubt I'll make it to 20 minutes.
Mr. Rogers, do you want notified at the end of any amount of time?
A minute to guys. On here.
All right, let's instruct, and then you all can close. What is generally referred to as the 404B instruction, the one that I gave after Officer Stevens testified. The law says it should be given also at this point. Do you remember what I'm talking about, Mr. Deegan?
Yeah.
Okay. Do you want it given again?
You know, I would appreciate that, given the fact of the prejudicial nature of what was said, because what can be implied from that was highly prejudicial.
Okay. Sometimes people don't like those issues being brought up in front of the jury again, and that's why I just wanted to check.
No, I think it should be enforced again.
I am going to ask, of course, in front of the jury, whether you have any more evidence, Mr. Deegan, so the jury can hear you say.
I don't think I've published the complaint in front of them.
Well, it'll be available for them, and I'll tell them that.
Okay.
All the exhibits will be available for them if they want to see it. And I don't know, did we tell them what it was?
No, because Bill wasn't here, and then we decided while they were out.
Is it okay if I just tell them that it is a copy of the complaint that you filed with the West Virginia Supreme Court of Appeals?
Yeah, that's fine. That's
Okay.
fine. Yeah, I just wanted to make sure they knew, because I didn't get a chance to say, can I publish this to the jury?
Right. And then if they want to see it, they'll be able to see it when they deliberate. Is that acceptable?
Yeah, that's fine.
Okay. I'll ask the jury I'll say, once the jury comes back in, I'll say, Mr. Deegan, do you have any other evidence? And then you answer however you wish to answer. And then I'll ask the state, of course, if they have any rebuttal. If appropriate at that time, then we'll just go ahead and instruct. Okay, let's have the jury. Ladies and gentlemen of the jury, Defendant's Exhibit 5 was admitted. And I think there was some brief testimony, but we're not sure, so we just want to let you know that is a copy of the complaint or petition that Mr. Deegan filed with the West Virginia Supreme Court of Appeals. And that's been admitted, and that, along with all the other exhibits that have been admitted, will be available for you to review during your deliberations, if you would like to see that or any of the other exhibits. All right, Mr. Deegan, do you have any other evidence?
No.
Mr. Rogers, any rebuttal?
No, Your Honor.
Ladies and gentlemen of the jury, at this point in the trial, the judge is required to inform you as to the law applicable to this case to govern you in your deliberations. And just to let you know, a copy of these instructions will also be available for you to review during your deliberations if you want them. All you have to do is let us know that you'd like to have a copy, and you'll have a copy, just like the exhibits will be available. In any jury trial, there are in effect two judges. I'm one of the judges, the other is you, the jury. It is my duty to preside over the trial and determine what testimony and evidence is relevant and admissible under the law for your consideration. It is also my duty at this stage of the trial to instruct you on the law applicable to this case. You, as jurors, are judges of the facts. That is, you are to determine what actually happened in this case. But in reaching your decision as to the facts, it is your sworn duty to follow the law that I am now in the process of defining for you. You must not change the law or apply your own idea of what you think the law should be. Both the court and the jury are bound by the law as stated in this charge. You are not to single out one instruction alone as stating the law, but must consider the instructions as a whole. Neither are you to be concerned with the wisdom of any rule of law stated by me. Regardless of any opinion you may have as to what the law is or ought to be, it would be a violation of your sworn duty to base a verdict upon any view of the law other than that given in the instructions of the court, just as it would be a violation of your sworn duty as judges of the facts to base a verdict upon anything other than the evidence in this case. Nothing said or done by the lawyers who have tried this case is to be considered by you as evidence of any fact. And again, since Mr. Deegan is representing himself, whenever I say in these instructions lawyers or counsel, I'm referring, of course, to Mr. Deegan in his role as representing himself in this case. The function of the lawyers is to point out those things that are most significant or most helpful to their side of the case, and in doing so, to call your attention to certain facts or inferences that might otherwise escape your notice. In the final analysis, however, it is your own recollection and interpretation of the evidence that controls in this case. What the lawyers say is not binding upon you. Your verdict shall be based upon the evidence as you heard it from the witness stand and as you recollect it, not as the lawyers may recollect it. Likewise, nothing I have said or done at any time during the trial should be considered by you as evidence of any fact, or as indicating any opinion concerning any fact, or the credibility of any witness, or the weight to be given to any evidence. You should disregard entirely questions and exhibits to which an objection was sustained, or answers and exhibits ordered stricken out of the evidence. It is not the province of the jury to determine the admissibility of any exhibit or other testimony. Do not draw any conclusions or speculations as to why or why not certain testimony or other evidence was either excluded or admitted. Although you may consider only the evidence in this case, you are permitted to draw such reasonable inferences from the testimony and exhibits as you feel are justified in the light of common experience. In other words, you may make deductions and reach conclusions which reason and common sense lead you to draw from the facts which have been established by the testimony and evidence in this case. You may also consider either direct or circumstantial evidence. Direct evidence is the testimony of one who asserts actual knowledge of the fact to be proven, such as an eyewitness. Circumstantial evidence is proof of other facts and circumstances, which from the usual connection of things and from the relation of cause and effect, leads to the reasonable conclusion that the facts sought to be proved exist. The law makes no distinction between the weight to be given to either direct or circumstantial evidence. It requires only that before a defendant can be convicted, you must carefully weigh all the evidence and be convinced of the defendant's guilt beyond a reasonable doubt. Now, I have said that you must consider all the evidence. This does not mean, however, that you must accept all the evidence as true and accurate. You are the sole judges of the credibility or believability of each witness and the weight to be given to his or her testimony. As used in this charge, credibility of a witness means the truthfulness or lack of truthfulness of a witness. The weight of the evidence means the extent to which you are or are not convinced by the evidence. The number of witnesses testifying on one side or the other on any issue is not alone the test of the credibility of any witness or the weight of the evidence. If warranted by the evidence, you may believe one witness against a number of witnesses testifying differently. The tests are: how truthful is the witness, and how convincing is his or her evidence in the light of all the evidence and circumstances shown. In determining the credit and weight you will give to the testimony of any witness who is testified before you, you may consider if you found from the evidence his or her, you may consider it found by you from the evidence, his or her good memory or lack of memory, his or her interest or lack of interest in the outcome of the trial, his or her demeanor or manner of testifying, his or her opportunity and means or lack of opportunity and means of having knowledge of the matters concerning which he or she testified. The reasonableness or unreasonableness of his or her testimony, his or her apparent fairness or lack of fairness, and from these and all other conditions and circumstances appearing from the evidence, you may give to the testimony of the witness such credit and weight as you believe it is entitled to receive. A witness may be discredited or impeached by contradictory evidence, by showing that he or she testified falsely concerning a material matter, or by evidence that at some other time the witness has said or done something, or has failed to say or do something, which is inconsistent with the witness's present testimony. If you believe that any witness has been so impeached, then it is your exclusive province to give the testimony of that witness such credit and weight, if any, as you may think it deserves. You may believe such parts of their testimony as you believe to be true, and reject such parts as you believe to be false. Or you may refuse to believe any part of such testimony, for it is a matter for you to determine, from all the testimony taken and all the circumstances surrounding this case, what witnesses have testified truthfully, and what ones, if any, have testified falsely. The defendant, Tomas Deegan, has no duty to take the witness stand as a witness on his own behalf. And if he does not do so, this is not evidence, and you should draw no inference therefrom as to his guilt or innocence. You should entirely disregard and not discuss it. The case that you have been sworn to try is a criminal case. The state has the entire burden of proof in criminal cases to prove the guilt of the defendant as charged in the indictment beyond a reasonable doubt. This burden never shifts to a defendant, for the law never imposes upon a defendant in a criminal case the burden or duty of calling any witness or producing any evidence. Criminal cases are brought to court by way of what we call an indictment. The indictment, or formal charge against the defendant, is not evidence and is not to be considered by you as having any weight whatsoever as evidence against the defendant. No juror should permit himself or herself to be influenced against the defendant because of or on account of the indictment in this case. The law presumes the defendant to be innocent of the crime charged in the indictment. Thus, a defendant, although accused, begins the trial with a clean slate, with no evidence against him. And the law permits nothing but legal evidence presented before the jury to be considered in support of any charge against the accused. So, the presumption of innocence alone is sufficient to acquit a defendant unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in this case. It is not required that the state prove guilt beyond all possible doubt. The test is one of reasonable doubt. A reasonable doubt is a doubt based upon reason and common sense. The kind of doubt that would make a reasonable person hesitate to act. Proof beyond a reasonable doubt, therefore, must be proof of such convincing character that a reasonable person would not hesitate to rely or act upon it. The jury will remember that a defendant is never to be convicted on mere suspicion or conjecture. If the jury views the evidence as reasonably permitting either of two conclusions, one of innocence, the other of guilt, the jury should, of course, adopt the conclusion of innocence. It is not sufficient to prove that the defendant was probably guilty, but such guilt must be established by strong and sufficient evidence to remove from the minds of the jury every reasonable doubt to the contrary. If, after considering all the evidence in this case, there remains in the minds of the jury a reasonable doubt as to the guilt of the accused is entitled to the benefit of that doubt, and you must acquit him. Before the defendant can be convicted, the state must overcome the presumption that he is innocent and prove to your satisfaction beyond a reasonable doubt that he is guilty as charged in the indictment. The offense charged in the indictment in this case is making terroristic threats. You may return one of two verdicts under the indictment. They are guilty of making terroristic threats and not guilty. Making terroristic threats is knowingly and willfully threatening to commit a terroristic act with or without the intent to commit the act. A terroristic act is an act which is likely to result in serious bodily injury or damage to property or the environment and intended to intimidate or coerce the civilian population, influence the policy of a branch or level of government by intimidation or coercion, affect the conduct of a branch or level of government by intimidation or coercion, or retaliate against a branch's level or level of government for a policy or conduct of the government. Before the defendant, Tomas Deegan, can be convicted of making terroristic threats, the state of West Virginia must prove to the satisfaction of the jury beyond a reasonable doubt that the defendant, Tomas Deegan, in Wood County, West Virginia, on or about a certain date in September 2015, did unlawfully, intentionally, knowingly, and willfully threaten to commit a terroristic act with or without the intent to commit said terroristic act. If after impartially considering, weighing, and comparing all the evidence, the jury and each member of the jury is convinced beyond a reasonable doubt of the truth of the charge as to each of these elements of making terroristic threats, you may find Tomas Deegan guilty of making terroristic threats as charged in the indictment. If the jury and each member of the jury has a reasonable doubt of the truth of the charge as to any one or more of these elements of making terroristic threats, you shall find the defendant, Tomas Deegan, not guilty. The term threat or threat is a communicated intent to inflict physical or other harm on any person or on property. A declaration of an intention to injure another or his property by some unlawful means. An avowed present determination or intent to injure presently or in the future. You have heard evidence concerning alleged conduct or other acts of the defendant which are not charged in this indictment. You are instructed that such evidence is not admitted as proof of the defendant's guilt on the present charge. This evidence is admitted for a limited purpose only, and it may be considered by you only in deciding whether a given issue or element relevant to the present charge has been proven. In this instance, the evidence of the defendant being on home confinement may be considered only for the purpose of determining whether the defendant had the opportunity to commit the crime or be on the conference call, and whether the defendant was in Wood County on the date of the alleged crime. You may not use this. Such evidence is not relevant to any other matters, such as the character of the defendant, whether the defendant is a bad person, or whether the defendant has a propensity or the disposition to commit the crime charged. This evidence may not be considered in that regard, since the defendant's character is not an issue. In addition, it is not proper for the state to prove a criminal case by evidence that a defendant may have committed other criminal acts or may be a bad person. Accordingly, this evidence may be considered by you only for the limited purpose for which it has been admitted. You will note that it is alleged that the offense was committed on or about a certain date. The proof need not establish with certainty the exact date of the alleged offense. It is sufficient if the evidence in the case establishes beyond a reasonable doubt that the offense was committed on a date reasonably near the date alleged. I caution you, members of the jury, that you are here to determine the guilt or innocence of the accused from the evidence in this case. The defendant is not on trial for any act or conduct or offense not alleged in the indictment. You are in no way concerned with the civil liability, if any, of the defendant to any person for any of the acts and conduct described to the defendant in the evidence. Neither are you called upon to return a verdict as to the guilt or innocence of any other person or persons not on trial as the defendant in this case. Also, the punishment provided by law for the offense charged in the indictment is a matter exclusively within the province of the court and should never be considered by the jury in any way